Hello, my name is Ken Novenstern from Fredman Baken Novenstern LLP, and today's video is about the equitable distribution law. And this law was written in 1980, and it is really the foundation of almost everything we do in divorce actions in New York. And even though it is now over 40 years old, there are still situations that come up which we find challenging in terms of specifically identifying and or the division of assets that the parties might have. Recently, I talked about the division of shares of stock, which were part of stock grants received by the wife in a case. And we got a financial person involved to do calculations for the marital and separate portion of those shares of stock. And hopefully they're in the process of being transferred right now in terms of the shares that my client is entitled to receive from the wife. And this morning I was talking with a client concerning an issue that keeps coming up in his case with a position taken by the other side concerning what is called wasteful dissipation of assets. And just to read a little bit to you on the topic of wasteful dissipation, because we did some research today to get recent cases addressing different situations. And one of the appellate divisions, the second department, which is the appellate division that covers the Westchester County area and other locales nearby, the court said, the courts have long recognized that economic fault, which consists of dissipation or secreting of assets, or other conduct which unfairly prevents the court from making an equitable distribution of marital property, has generally been considered relevant to the distribution. And they mean the distribution of assets between the parties. And that case was the famous Blickstein case from 1984. And my recollection is that in that case, the wife spent virtually all of the assets of the parties over a very short period of time. And that was obviously frowned upon by the court. So the idea of one party improperly or inappropriately dissipating or secreting assets is something that a court can look at, can take into consideration, and can impact the division of assets. And in my particular situation, the question is whether one party appropriately used marital assets for ordinary marital expenses. And in my opinion, in our situation, I do not believe that there was any dissipation of assets. We did find several cases from the last few years where courts addressed this issue, and oftentimes one of the cases involved a situation where the husband spent money on his second family, and that was found to be improper use of funds, and the wife therefore received an offset or a credit with regard to the money that the husband spent on his second family during the marriage. So it's an interesting set of issues. These interesting issues keep coming up under the equitable distribution law. And if you have questions concerning division of assets in your case, separate property, please feel free to contact me and we can discuss the case law and the overall outlook with regard to how that issue might be handled. Again, Ken Novenstern, and feel free to call me at 914-997-9070 and discuss any issue that's applicable to your situation. Take care.